When it comes to insurance policies, courts generally disfavor forfeitures, or allowing an insurer to keep premiums paid and rescind the policy without paying the insured compensation. However, an insurer may be able to rescind an insurance policy if the policy was obtained through fraud or misrepresentation. In Smet Farm Mutual Insurance Company of South Dakota versus Busskohl, the South Dakota Supreme Court considered whether a material misrepresentation in an insurance application allowed the insurer to rescind the policy. In 1983, a fire destroyed David Buskohl's childhood home. At the time, Busskohl was living in the home with his parents. Following the fire, Buskohl's parents used the insurance proceeds to build him a home. In 1990, the newly built home was also destroyed by a fire. A local fire marshal investigated and, in his report, suggested that it was possible the cause of the fire was arson by Busskohl. Busskohl was then arrested for arson, although the charges were later dismissed. Following the second fire, Busskohl and his wife built another home at the same location. Afterward, the couple sought to obtain a homeowner's insurance policy with American Family Insurance Company, but American refused because of Buskohl's history. In 2004, Busskohl applied again for a homeowner's insurance policy with Smet Farm Mutual Insurance Company of South Dakota. In his application, Busskohl was asked whether another insurer had canceled, refused, restricted, or declined to renew similar service. Busskohl answered no and later represented that his statements were true and correct. After reviewing the application, Smet approved Busskohl and issued a policy. In 2005, Buskohl's home was destroyed by another fire. Smet then paid Busskohl nearly $500,000 under the policy. 2 years later, Busskohl sued the agent and agency through which he obtained the policy for negligence. But during litigation, Smet discovered that Busskohl had previously been refused a policy with American. Subsequently, Smet sued Busskohl in state circuit court to rescind the contract and recover money paid. Specifically, Smet argued that Busskohl made a material misrepresentation in his application by stating he hadn't previously been refused a policy and that it wouldn't have approved his application but for the misrepresentation. Smet then moved for summary judgment, which the court granted. Busskohl appealed to the South Dakota Supreme Court.